abom na egusu bubom in the Sedina Tamakloe case. Na ma hu samanfo blame the Attorney General. No mitie Samuel Uku, mitie lawyer John Dark. When some people are blaming Attorney General, say na wanye bibia. In fact, you are Godfred Dame no we hanan case. Also mungo bus Attorney General. But you see how the Attorney General spoke. Say na US court to cry eje charges need to ma. How much more Ghanaian court into bar appeal no make us that's my inferment from the posture. Any the war can't some no. The Attorney General do nothing at all, and then me prove with documents. I know in my hand. I catch us 4 grounds, you know, the general summary grounds I made them out. I'm catch us I don't have the liberty to share the document, but today I'll share the document for you. So the work didn't come on. You can also go there. Oh, me page we 43 pages. Attorney General, and so they come out court, you know, on the 9th of April 2026, 9:40 a.m. and Attorney General file here. And me bought 4 brothers, man. I think you have a clue on it, but I'll give you preliminary something that maybe the Court of Appeal didn't adduce their mind to. And now, me brood over a day, I'm going to travel 7-8 videos. In maybe then I decided to brood on the matter. Some market can the document I've shared, try to summarize everything in my mind before I sleep. And I mean, who are they? I think maybe there's a reason why OSP forces a Ken Ofori-Atta, Baba Ghana, no stand her hook or crook. No, my cousin tried in absentia. But OSP is a chinchina, so Ghana, Baby Crock, say, obey Zoom conference. OSP can say one chance, so Ghana. I think some material reason be say. And I'll share that in this video. The video, you know, a young kwan here, yes, and a constitutional review will be a video in but let's have that conversation. And I think that the Attorney General must not be blamed in this matter. Yes, they have their issues. I've had my disagreement with them, but on this matter, maybe you will say today, me my dream. Based on what I've seen, that I'm come to share with you, blame Attorney General in ye. Subscribe me. Now click the bell notification. The video be to my behu. Now what Bawumia, you will certainly have a comment. Feel free, leave the comment in the comment. Leave the comment in the comments as you have sure say Obeko Goldberry construction method and episode se masasa nkrata some the documentations related to your house in Goldberry. Ebe this age money na the amount. You certainly maybe a person papa no mama and you probably be shown to be your brimpomba so addiction related issues, trauma related issues, aged care brimpomba maybe be a kama the amount. Normally when it is a long document we pick the relevant portion for. So I've been able to isolate relevant portions for you. It's 43 people started from page 7 where the Attorney General raised preliminary objections, and I think that it is very important for me to read what the Attorney General said for you. Or say, my lords, the antecedents to this case point to the fact that the appellant, Sedina Tamakloe, hearing was tried and convicted in absentia. She was sentenced to 10 years, but remained a fugitive from justice. As such, has not served even a day of the sentence imposed on her by a court of competent jurisdiction. So the Attorney General has even saying, "The will be a fugitive for justice." Attorney General answer question. So let's not belabor the point there. Okay. And this is from Godfred, this is from Dominic Ayeni. Though they indicated they will file the appeal in 2024, a day after they were convicted. That is Daniel Eximini Sedina Tamakloe. The written statement came after she was brought to the country. And that was when the Attorney General also filed his side to the real court. He is a party to the case. And I think that the problem is that when you read Attorney General's statement on the bar wants to be first line, what our attention has been drawn to. Your attention cannot be drawn to a case you're a party to. So I think say once was our phone on the cover MPP accusation about why is it using that the attention has been drawn to other one filing written statement be another be filing. But I think that statement, so I also not debating anybody who will say that on that matter. But let's go to the substance of the matter. Or say our criminal justice system has been marked by a persistent effort to balance coercive power of the state with the fundamental rights of an individual. At the heart of this balance is the concept of fair trials provided for in Article 19 of the 1992 Constitution that ensures that no person is deprived of liberties without due process. However, a specific procedural dilemma arises when an accused person, having been duly notified of criminal proceedings, chooses to abscond, leading to a trial and subsequent conviction in absentia. The legitimate question that arises is whether such an individual, now a fugitive from justice, retains the right to utilize the appellate machinery to challenge their conviction while remaining outside the reach of the law. And the Attorney General said, Article 19 is clear. Say, while the state has the power of the state, to do prosecutions and everything, and they must also balance with the fundamental human rights. Article 19 and attaching the raising constitutional issue, so the charges must be defined, the penalties must be stated. And this Article 19 is clear. But court, also inherent in the principles of prosecution and the court, and the court authorities in your say, Nipa no be challenge conviction at the toll so. She was duly notified of her charges. Why didn't she speak then? She decided to run away. This is Attorney General. This is Attorney General speaking. Me the lawyer. PhD in law na say. She decided to be a fugitive of the. In fact, she used the word abscond. She decided to run away. So the legitimate question you, the appeals court, must ask yourself is that can such a person come back and challenge the very processes she didn't subject herself to? That's what the Attorney General is saying. The Attorney General goes further to say that before we proceed to discuss the raised issue, it is pertinent to put the appellant case in a perspective and state that the fugitive appellant is not challenging the procedural steps which were taken in commencing the trial in absentia as not meeting the legal threshold for proceedings in absentia. What he is challenging is the outcome of the said trial. My lords, it is right that the right to appeal in Ghana is a creation of statute and underpinned by constitutional guarantees. It provides a mechanism for the correction of legal and factual errors made by lower courts. For a person convicted in absentia, understanding the statutory framework is the first step in determining whether an appeal can be mounted. That is not just filed, but effectively pursued and heard by the appellant body. It goes further to say that the Court Act 1993, Act 459, is the primary legislation governing the jurisprudence and the powers of the various courts in Ghana, including the appellate court. Section 11 of Act 459 established the jurisdiction of the Court of Appeal to hear and determine appeals from any judgment, decree, or order of the High Court or the Regional Tribunal. In criminal matters, this right is further elaborated to ensure that any person convicted of an offense has a pathway to seek a review of their case. So the Attorney General said that yes, the appeals court is there to look at reviews. It's not supposed to, say that because High Court has convicted you, there's no other place you can go. That's why the appeals court. So you can go and ventilate your views. They agree to all that. They are saying that using the Courts Act, the right to appeal is generally granted to any person who is aggrieved by a decision. This broad language suggests that the status of the person, that is whether they are in the custody or a fugitive, does not inherently distinguish the existence of this right. The Act provides that an appeal may be on a matter of law, a matter of fact, or a matter of mixed law and fact. This comprehensive scope is intended to ensure that the appellate processes can address various forms of judicial error, from the misapplication of the law to the misinterpretation of the evidence. To all appeals court, a matter of law, matter of fact, or both, and to ensure that the lower court are not an injustice to the person who has been convicted and has some no abotiano. But yeah, they say, however, after agreeing that you can go to the appeals court, you can go and ask questions about the judgment given to you at the regional tribunal or the High Court, and say, however, the Court Act grants the appellate court powers to regulate their own proceedings and to make orders that are necessary for the administration of justice. This includes the power to strike out appeals that are considered an abuse of the court process. This power, granted the judiciary and the common law fugitive disentitlement doctrine, put together, means that once Act 459 grants a right to appeal, the court may refuse to exercise its jurisdiction if the appellant is in active defiance of the law. This creates a situation where the right exists in theory but may be procedurally barred in practice. Or say yes, Act 459 grants anybody the opportunity to go and seek appeal. But once seeking the appeal, the court also reserves the right to throw away or to say that we will hear the appeal based on how the individual filing the appeal has discharged themselves in the course of the trial. And Attorney General this is what the Attorney General is saying. It goes further to say that it is important to shed light on the fugitive disentitlement doctrine at this point to enrich the argument. So Attorney General introduced the doctrine being law from the fugitive disentitlement or bechirim senate here. Or say, the fugitive disentitlement doctrine is an equitable doctrine which prevents an evasive party from obtaining standing in a court with authority it evaded. You don't say to a frauds Brian Tiasem. What woman in Tia? What ma? What bubu court in Tia? What ma? Why evade? These are the words of the Attorney General. To make us with Dania. This is why I'm saying that. Evaded. Nasa court in a buasam net and penifona transfer for a ma. Omo buasam net ya dia wo ban penifona wo bu o manim tia na wa ma na aho e be seeking reprieve na. O say there be anya sa because that doctrine in the law, fugitive disentitlement, e ma kwan say sa de ne be koso. Okoso ka say, thus it limits a person's ability to appeal as long as he or she remains a fugitive. According to the doctrine, an appellant court may dismiss an appeal when the person seeking the relief is a fugitive. It is important to state that per Article 11 of the 1992 Constitution, the laws of Ghana include the common law as well as the rules of law, generally known as the doctrines of equity. And was cited case where USA. He using that to back the point no making the say. And was cited case, Ortega Rodriguez was the United States 1993. He said that the fugitive from justice doctrine is a prudence, a wise. It's a wise device which court may invoke to stop fugitives from challenging criminal convictions in absentia. The driving force behind the doctrine is the idea that the criminal defendant, following conviction and initiation of appeal, should not be allowed by absconding to create a "has I win till you lose" situation. It is tried that under our law, a convict who wishes to initiate an appeal must comply with specific procedural requirements, the most important of which is the filing of a notice of appeal. According to the rules of a court, a notice of appeal in a criminal case must typically be filed within 30 days of the date of the judgment or the sentence. The act of filing a notice of appeal is a clerical or administrative task which notifies the court and the prosecution that the conviction is being challenged. At this stage, the physical presence of the appellant is not strictly required. A lawyer acting under the instruction, even if those instructions were given before the client abscond, can technically sign and file the necessary paperwork. It must, however, be stated that the filing the notice of appeal is not synonymous with mounting the appeal. It is our submission that the latter invoke the substantive hearing of the case where the presence of an appellant becomes necessary, and as such a fugitive status possesses a significant hurdle to the process. My lord, the jurisdiction of the Court of Appeal to hear an appeal, such as the instance case, is subject to several conditioned precedents, some of whom which are found in statutes and others in judicial policy. One of the primary limitations is the requirement that the appellant must not be in contempt of the very court system they are seeking to use. It is our submission that the appellant who fled the jurisdiction during the trial, who has avoided serving the prison sentence imposed by the trial court, could be viewed as being in a state of constructive contempt, and we urge this court to view her as such. This is why my submission, you do not say to choose submission mine. That to blame Dominic Ayeni and ye. Dominic Ayeni koso kase. Court na mami beji appeal. No some catch said the day near convict and no filing notice of appeal. Now written statement by Brian Cheno. Or say not the intiamraso. Say oh Ghana no share na chi krana and also possible. But appeal now obe filing. Nipa ni jame. The very court system now no nebe kasa yetieti na mraso. Sa court system no bu na nimutia. Bra wo bu court ni tani notify the charges into wo bibi kan sa stage na dey na wan kasa ansem ni nyina. Enti enya na ye kasa enya lawyers ye kira adwin nyina no court ne ne ye adwin. Attorney General ne ye adwin. Said now it goes further to cite authorities. So those is because it's not fair to blame the Attorney General. These are just his preliminary objections. On the objections of 4 issues, no, I'm watch any I'm already my 14 minutes. He goes further to say something here. We further state that the effrontery, listen to the tone, the effrontery of Sedina Tamakloe to mount this appeal when she had conveniently decided not to surrender to the jurisdiction of the court is something that that must not be countenanced by this honorable court, as the conduct of Sedina Tamakloe is an affront to the sanctity and integrity of the court. It is tried that once a competent court of law issues an order, it is expected to be obeyed, except and only when the order has been set aside. Or say effrontery na bufusem. So ono nenya Attorney General na ka say nye Jose to ono nenya mre eba. Say obe challenge process will journey through process. So one day across the process. Meanwhile, emrane ka say court to kasa ujitu unless there's a stay of execution. E say within your court na kaso. Sedina Tamakloe any court na kaso. And just a court na so countenance na what if you say the court shouldn't countenance this. As and when I make come baby. Ghana penny men junction a year so in the year ni koso. Na police for bun junction injunted funeral na ho ban. Yes, so. Now, this is the preliminary. One will say, and no crest Attorney General unready. These are the preliminary facts. I've given you the 4 broad areas later. What I say? Into Montreal, many BC. Now, having given you these preliminary objections, and I mean, kind in kahun. Okay, my main kind kakrans and kahun. Ote. It is a submission that the appellant Sedina Tamakloe's active defiance of being at large is a flagrant disregard of the judgment and orders of the court. That sentence says, as well as such, this honorable court should not entertain this appeal, as the conduct of Sedina Tamakloe is an affront to administration of justice. So the Attorney General is raising preliminary issues why even the appeals court shouldn't have entertained the matters on 3 basic grounds. Definitive disentitlement theory that if you cannot subject yourself to a process, you cannot come back and challenge that process. 2, you cannot come back and seek the same thing in the court. Again, he's saying that there is a constructive contempt of the court. You cannot decide to run from a court system, disregard it. And you see, the Attorney General is also telling us that Sedina Tamakloe didn't come briefly. She was arrested in the US. It took a court of US, meaning that she was fighting extradition to bring her to Ghana. If she was indeed ready to stand trial, if she was indeed ready to challenge, why was she fighting all these processes? That is Attorney General on the PhD in law. Yedi any PhD. Yedi anon koto. But now me catch us and me broody over the matter no. I think some yati as ye ni enti a OSP say chenchina achi na se Ken Ofori-Atta ba no. I think that in speaking to my lawyer friends, I know I'm name is senior colleague Austin Wood, they kasa for a very long time. One of the things that became apparent in the conversation is that in a trial of Ascensia, the state is limited. Wontumi case in for example, during the cross-examination, Wontumi implicated himself in a certain way. This is Justice Audrey Kokuvite speaking, where he said that the lawyers couldn't even challenge some of the things, and so that's the law, or that's the ruling. But said in the on one kasa wanye statement biya, there's no witness statement because we're done. One fair witnesses for the state to interrogate the witnesses to punch loopholes in the matter. We're done. The state, enquire a case, it's meaning that even if the state needed cross-examination to bring out certain evidences that will come from Sedina Tamakloe's mouth, those evidences are not available. So when you compare, for example, to the Wontumi case, where it became apparent that Wontumi Nkomobia with DD and then maybe in the course of the trial in court, aided the case of the state against Wontumi. Sedina Tamakloe didn't afford that opportunity. So like the Ken Ofori-Atta issue, he can also come back one day, say, the trial in absentia, go through this same route, and go scot-free. Is that not possible? It is possible. Based on all that is after, no, maybe one, I'm saying, maybe anything I always be any abri. And you see, I always say this thing, and I say it, I don't know how I couched it, but one Mahama channel can say, Attorney General can you be but at the end of the day, it is the court that will decide. Fortunately, I've done the ruling for you. Fortunately, I've given you other perspectives from other people. I think that at this point, maybe if there's no major issue, I'll leave everything here. And as I always do, I'll leave it to your judgment. Maybe I don't think that Attorney General should be blamed. That is my view. I think that these are the lessons we must learn and our approach to get Ken Ofori-Atta to also answer questions. That is all that I sought to do for you this morning. Into maybe the no. Also view the same, feel free and share that view in the comment section. We are now subscribe more subscribe and click the notification me the video be to my behu na wait me ahwe bi. Make sure so be sure see e dia ma me. Me hian o man Ghana see hian. Bye bye.